In news across the state, a federal court has sided with a South Carolina teenager challenging the legality of a state law that deals with which students can use which bathrooms at school.
State House reporter Mary Green explains what the decision means for South Carolina schools and what comes next.
This lawsuit challenges a rule the General Assembly put into the state budget here last year and has kept in place since then. It requires people use school restrooms and locker rooms based on the gender that's on their birth certificate.
What it's targeting is appropriate policy for children in South Carolina. An appropriate policy for children in South Carolina is that boys go to the boys' room and girls go to the girls' room.
For many trans students, bathroom bans aren't abstract policy debates. They are daily reminders that their existence is being questioned.
Last year, a transgender teen sued the Berkeley County School District and its superintendent, along with the State Department of Education and state superintendent, to challenge the law. This week, the federal Fourth Circuit Court of Appeals issued a temporary injunction saying the student, identified as John Doe in the lawsuit, can use the boys' restroom at school. It also denied the state's request to dismiss the lawsuit.
Transgender students are part of our school communities. They show up at school every day to learn, and we should make sure that their safety and their well-being is taken into account just like any other student.
But the rule remains in place for everyone else in every school and district across South Carolina, and those that don't comply could lose some of their state funding. This comes 5 years after the same appeals court struck down a similar law in Virginia in a case the U.S. Supreme Court declined to take up.
And they said that bathroom bans like this violates the constitutional rights of trans individuals. South Carolina continues to violate that law by passing provisos and laws like these.
Republican Senator Wes Clymer introduced the measure at the State House and says even though the ruling is narrow, he's still disappointed with it.
And we look for a better outcome in a more reasonable court that hopefully protects the children in South Carolina from those who, men who want to enter the girls' locker room.
South Carolina's Attorney General says the state plans to appeal this ruling, and the Department of Education adds it believes this is a question that'll ultimately be decided by the U.S. Supreme Court. Reporting from the State House, I'm Mary Green.
And we should also mention the rule is temporary, in effect only as long as the legislature keeps putting it into the state budget. But multiple bills have been filed at the State House to make it permanent, which lawmakers can take up when they return to Columbia in January.